This is part 3 of chapter 11. Chapter 11, part 3 lecture video. Slide 21, Mapp versus Ohio. Police were looking for a bombing suspect and gambling equipment. They went to Mrs. Mapp's house. She refused entry without a warrant. They returned later and forced entry, waving a fake warrant. They didn't have a warrant, but they said they did. No suspect equipment was found. Some pornography was found, and she was arrested for that. It was illegal at the time. Supreme Court ruled that evidence found by both federal and state officials during the illegal search is inadmissible. Slide 23, fruit of the poisonous tree. Fruit of the poisonous tree means this. Evidence that's derived or obtained from an illegal search is also admissible. So if you did an illegal search, any evidence that you get in that illegal search is illegal. An example, diary discovered in an illegal search with directions to illegal drugs, and then you find those drugs, that's fruit of the poisonous tree. You cannot admit that. Getting a warrant after the illegal search will not allow evidence to be admitted. So it's so important to follow it right. Slide 24, Wong Sun, sometimes called the Chinese laundry puzzle case due to all the colorful names. The police executed an illegal warrantless search of Blackie Toy's laundry. Toy implicated Yi, who then implicated his supplier Wong Sun. Later, Wong Sun voluntarily returned to police and confessed. At Yi's trial, Toy's statement were excluded under the fruit of the poisonous tree doctrine. Wong Sun's confession, however, remained admissible as the court created an exception. Attenuated taint. Okay. Slide 25, exceptions allowing admission, good faith. Police objectively believed the search was legal. That would be good faith. A warrant was valid on its face. New constitutional law published later by a higher court. Inevitable evidence discovery. If evidence would absolutely have been discovered later in a valid search, it could fall under the inevitable discovery. Bottom of page 337 talks about good faith exception. The top paragraph of the good faith exception. Officers must be acting under an objective belief that what they are doing is constitutional. They must stay up to date on the law of searches, seizures, and confessions. The facts must be such that a reasonable officer could have made an honest mistake. If the officer has an ulterior motive, the exception does not apply. However, acting in good faith is not enough. Let's see what it says. The rule applies only in a few distinct situations. And then it describes those a little bit more in detail. Let's look at the bottom of page 338, inevitable discovery. It's based on the idea that the police would have found the evidence even if they had not used unconstitutional procedures. Toward the bottom of that paragraph, the prosecution bears the burden of convincing the judge that the evidence would inevitably have been discovered through legal methods. Table 11-4 on page 339. Let's look at that. The exclusionary rule. Statements made by Williams after police used improper interrogation techniques telling the officers where to find the body of the victim. Inevitable discovery exception. The body of the victim and any evidence discovered was admissible because there were hundreds of people searching for the victim and it was inevitable that the body would have been legally found. That was an example. Slide 26, exceptions, independent source. Police relied on some independent valid source. Read, let's see here, page 339, 11-5, independent source exception to the exclusionary rule. Exclusionary rule. Evidence observed in Frank's apartment immediately after his illegal arrest is not admissible. Independent source exception. Officers legally obtained a search warrant based on facts that were obtained independent of the search of Frank's apartment immediately after his illegal arrest. When executing the warrant in Frank's apartment, they found the same evidence the other officers had observed but had not seized. Slide 26, public safety. Public faces immediate physical danger if the police do not search, such as a lost gun. Page 340, table 11-6. You can read that. Knock and announce. If it's violated, the requirement of a knock and announce, a subsequent search is not invalid. So even if the knock and announce isn't done right, the subsequent search is not invalid just because that wasn't done right. Slide 27, procedural exceptions. Harmless error admission did not alter the trial. Grand jury not subject to exclusionary rule. Impeachment, the exclusionary rule should not support perjury. Civil cases do not involve the state. Deportation, not a formal criminal procedure. Sentencing, no clear rule from the Supreme Court. Parole revocation, convicted parties have fewer rights. Searches by private parties do not involve the state. Let's look at page 341. Grand jury, unconstitutionally obtained evidence may be introduced for the grand jury to consider when returning an indictment, even though the same evidence will be inadmissible at trial. Impeachment. Although the exclusionary rule prevents the prosecution from using illegally obtained evidence to establish its case, the rule is not a license for the defendant to commit perjury. The court held that if a defendant testifies during trial, statements he or she made to the police can be used for impeachment, but it must relate to the topics raised during direct examination. Civil cases. The exclusionary rule does not apply in civil cases. Deportation. The Supreme Court ruled that unconstitutionally obtained evidence could be used in hearings for immigration and customs to deport aliens. Sentencing. Although the Supreme Court has not specifically ruled on the question, many lower courts permit illegally obtained evidence for sentencing hearings. Parole revocation. The exclusionary rule does not apply at parole revocation hearings. Search by private person, the Fourth Amendment does not protect against actions by people who are not part of a government operation. Evidence seized by a private person does not become inadmissible under the exclusionary rule. To qualify for this exception, the person must be acting on his or her own. Whew, that's a lot. Slide 29. This is the last part of this chapter. Roshan versus California. Without a search or arrest warrant, the police entered Roshan's house and bedroom. Roshan swallowed some capsules, which the officers tried to make him vomit. Later, the police pumped his stomach and got the drugs. Evidence was excluded because it violated the 14th Amendment due process provision. The court called the police action a shock to the conscience. That's the end of chapter 11 lecture.